Good morning, Chair. Good morning, Committee and guests. My name is John Oliver and I am the Queensland State Secretary of the United Firefighters Union. With me is John Spreckley, our Senior Industrial Officer. UFUQ represents approximately 2,500 firefighters who respond to all emergency incidents and have a proud community standing. They will all be affected by this bill. United Firefighters Union of Queensland thanks the Committee for the opportunity to provide a brief written submission into the Industrial Relations Bill. We trust that the Committee will consider our written submission in your deliberations about this bill. We also adopt and support the submissions made by the Queensland Council of Unions. By way of general comment, UFUQ believe the bill is unnecessary and we support the retention of the existing laws, which have worked well and balanced the interests of all parties, employees, employers and the state government, particularly in the role of employer. In fact, our members have been completely taken by surprise by this bill, which has been introduced on the advent of their negotiations for a new collective bargaining agreement. We concur with those submissions which suggest that the bill is designed to tilt bargaining and industrial relations arrangements in the government's favour, in circumstances where the government is the employer. As set out in our written submissions, our key concerns are the bill is unnecessary and the current legislation works well. The restrictions on the taking of industrial action are inconsistent with the ILO organisations or obligations. The incorporation of J.J. Richards' amendments are inappropriate because they have been based upon a different statutory context. The Federal Court made a correct decision in the first place, which the bill attempts to overturn by amending a completely different statute in a different jurisdiction. The plan to restrict our members from taking legal industrial action until the government decides that it is ready in bargaining or to bargain is wrong. We've been trying to get a meeting with the QFRS, which is the fire service, to discuss bargaining for a few weeks now. What if the government keeps stalling? Our members' rights to motivate the government to get on with bargaining will have been taken away. The J.J. Richards amendment runs the risk of encouraging tardy and inefficient industrial relations activity by government or government agencies. Our members should be entitled to motivate them if needed. There is no need to include provisions allowing for a termination of industrial action by the Minister. The Federal Act includes similar provisions to allow the Minister to intervene in protracted disputes where the Federal Government is not the employer. In our state system, the state government is the major employer and has already sufficient power, influence and rights under the existing Act to stop or prevent industrial action. Further, the 21-day period following a ministerial declaration is too short a period to conclude an agreement. Currently, the independent tribunal can determine whether negotiations are exhausted in particular circumstances. That system would work better than a one-size-fits-all approach, allowing just 21 days. The provision allowing the government to abandon negotiations with the union and pull a ballot directly to employees seems a little confused. The amendments move the right...
Sorry, John, your time has expired. Any supplementary questions to that? No? Member for Inala.
Thank you, Chair. Can I please address my questions to Mr Oliver? Welcome. Thank you for your attendance today. You stated in your opening address that the existing laws in Queensland are adequate, and you also raised concerns about the time frame given to respond. What do you believe would have been the adequate time frame?
Are you referring to after negotiations break down, there's a 21-day period? No,
about responding to the changes to the bill, to the Act.
Yeah, we would have at least liked to have had a month. Obviously, with the scope of these changes, there's a lot to consider.
Okay.
And it's evident today that some of the decisions that were made in putting this bill together, that a lot of these considerations weren't put forward.
Did anyone from the LNP consult with you before the election about any proposed changes to the Queensland industrial relations system?
No, not at all. And if you look at the explanatory notes, it actually has who they actually consulted with. I think it's in there. Anyway.
So prior to the election, there was no consultation, and before the bill was introduced into the Parliament, did the Minister or anyone from his office seek to contact you about your views before the bill was introduced into the Queensland Parliament?
No, I haven't had the pleasure of meeting the Minister or anyone from his office as yet.
Okay. Can I just follow up by asking, how does this bill risk the government legislating unfair advantage to themselves? So this is about the fiscal strategy requirements that have been raised by many members here today.
Well, basically what you have is an employer being able to legislate to give an advantage to them by, I guess, being the person we're negotiating with. And if a person has a higher ability as legislative rights over the employees by way of the union, then obviously that's going to cause a disadvantage to the union or the employees under that matter. So what we'd be looking for is for a more level playing field, or to keep existing rights, I guess, the QARC, which has proven to be fair and efficient and effective.
Okay, thank you.
The question is to the United Firefighters Union, back to Mr. Oliver. What confusion could occur if bargaining between the government and the union has commenced, but that is outstanding? There are outstanding issues. The government wants to proceed with the agreement directly with the employees. What issues do you see coming out of that?
What I see is when negotiations have commenced with the union and it gets to a position where there's a stalemate, you may have the employer directly bargain with the employees or even take it to ballot. From that point of view, the person receiving the ballot may have concluded that the union has agreed to the ballot that's coming forward. Secondly, the union may not have even seen the ballot that was going forward to the employees. It may be a completely different ballot, and I guess that has been done by unscrupulous employers in the past. We believe that the union should be notified in any event, and to be able to have negotiations and issues when dealing with these industrial instruments.
I do have a follow-up, if that's okay, Mr. Chair. Obviously, the way that the bill has been drafted and the powers that will come along with the legislation if it's passed, what misuse of power could occur when the minister, as part of the government, who is the employer, has the unilateral power to terminate protected action?
Look, obviously to unsettle the workforce, especially firefighters, they believe that the world should be just and fair. And they believe that the minister is their employer, and if he has the ability to make that determination over the employees when we're doing something that we believe is legitimate and legal, then I believe that they would really take a backward step in the view of their opinion of the government. And I also believe that firefighters are a fair and credible part of the workforce. We're not particularly irrational in our behaviour or decisions. We see this as being irrational, and this decision is certainly not in the best interests of firefighters, other unions, members, and certainly not the community of Queensland.
Could I add to that, John Badhams, QCU? I think it's important to emphasise that workers only have the right to take industrial action for certain periods during the bargaining period. They're not allowed under the Act to take legal industrial action outside that period. And if you look at the bargaining dynamic, one of the few powers that workers have in that dynamic with a difficult employer is to actually either withdraw your labour or have the ability to threaten to withdraw your labour. Now, if your employer is the government and the government has the power to terminate any industrial action, that is in fact reversing that bargaining power. The minister can, and I suggest may, use that power in the bargaining process to ensure they have an unfair advantage. And all of the international covenants indicate through the ILO that workers do have and should have a right to take industrial action in support of their legitimate claims. And we believe this impinges very strongly on that.
Just supplementary for Mr. Badhams. Obviously, there are potentially risks in imposing civil penalties on the failure to comply with the direction of a politician as opposed to a judicial body. Could you let us know what your understanding of those risks might be?
Well, they're quite incredible fines, and when you consider that the term industrial action is a very broad term, it may not involve a threat of a strike or a stop work. It could involve, during the legitimate bargaining process, workers wanting to withhold work in relation to particular matters as a legitimate weapon. These fines can be imposed on workers for taking any form of industrial action, strike or otherwise. And again, I just emphasise the fact that internationally, the right for freedom of association and the right to take industrial action in pursuit of legitimate claims should not be impaired. And that's why we're suggesting, if the government is intent on keeping this provision in, there should at least at a minimum be a referral to the Commission for the Commission to consider the matter before the Minister can actually take that action.
Thank you.
John Oliver, Firefighters Union. Just that the 21 days post-ministerial declaration is also too short. We find that it would be very difficult to come to a conclusion in any negotiations in that time period. And in conclusion, the UFU believe the bill is unnecessary and to an extent misconceived. I refer the committee to our written submission for further detail. I am grateful for the opportunity to speak with you about this bill this morning on behalf of 2,500 firefighters. But it's not just firefighters, it's all frontline employees, Queensland Police, ambulance officers, paramedics, hard-working citizens, working to protect Queenslanders. Thank you.
Thank you. Kylie?